join me in welcoming our presenters today. And Amy and Marisol, I will turn it over to you.
Thank you, Juan. I just want everyone to know that there's nothing in our presentation that should be considered legal advice. So I want to start by telling you who we are. To give a very brief history, in 2014, the Second Judicial District Court established the Mortgage Alternatives Program called MAP to assist homeowners facing foreclosure. In 2016, the MAP was reorganized and the Foreclosure Settlement Program was established to operate in a more efficient and effective manner. The Foreclosure Settlement Program, which we will call FSP throughout this presentation, is a court-ordered settlement facilitation program providing foreclosure mediation in the Second Judicial District and 7 other New Mexico districts. The program is provided at no cost to the parties. We have 4 settlement facilitators and 2 judicial specialists. As you heard in our bios, Amy, my co-presenter, is one of our settlement facilitators, and I supervise the FSP. As you may or may not be aware, residential mortgages are federally regulated. However, state law governs the foreclosure process. So what the FSP does is help homeowners or their heirs and mortgage companies have meaningful conversations to work toward settlement in residential foreclosure cases. Now, there are many types of residential mortgage loans that are in the FSP cases, and those include conventional loans, government-sponsored or insured loans like FHA, VA, Fannie Mae, Freddie Mac. There are second mortgages, home equity loans, and reverse mortgages. Our goal is to provide a dignified process for the parties to discuss options, to make decisions to resolve their foreclosure case. And it provides a unique opportunity for a borrower or their heir to talk to the mortgage company and their attorney in a confidential and safe space about what brought them into foreclosure and what they can do to settle the case without further litigation. While some homeowners do get attorneys to represent them, many participate pro se, meaning they represent themselves. And they are able to successfully engage in the settlement facilitation process and to resolve the case without having an attorney. At this time, I'll turn this over to Amy to discuss what settlement facilitation is. And Lisa, if you could change slides. I forgot to tell you that.
And we're actually going to want to hop on to the next slide. Thank you, Lisa, and thank you, Marisol. So as Mari was mentioning earlier, the goal of settlement facilitation within our program is to provide a safe and neutral forum to discuss resolution for foreclosure residential cases. Now, in the program, one of the great benefits to the public is that the litigation is stayed to allow homeowners to engage in these discussions. What that means is essentially the litigation is placed on pause. So the bank can't sell the property, no one can be evicted while they're in the program. So it really does provide a nice opportunity for people to have those discussions, to find a resolution in a lower fear environment, so to speak. Settlement facilitators are neutral third parties, so we don't provide legal advice. We can tell people about resources that can assist them, however, and that's a great resource that we provide to pro se litigants. We are often telling the pro se litigants about resources that may be able to assist them, including free legal representation for those who qualify or free housing counseling. Now, in addition to providing a forum for people to have these discussions, we also make sure that translation services are available for anyone who may need them. We have a lot of Spanish speakers in our program. Another way that we ensure access to justice in settlement facilitation within FSP is to make sure that individuals who are, for example, elderly or who have some sort of disability still have access to our program. So, for example, sometimes we have elderly individuals who may need help in accessing the program because they don't have email, for example. So we make sure that we have full contact information for everyone and we can facilitate that conversation fully and completely. Now, the parties will decide the terms of any settlement that they come to within the program, subject to applicable federal or investor rules and guidelines, and subject to the options that may be available. The real benefit, however, is equaling the playing field between the homeowner and the bank so that they have one person that they're speaking to on the bank side, which is the plaintiff's attorney. This really helps to minimize any miscommunications that may happen between the parties otherwise outside of the program, and it also helps to prevent unnecessary litigation. So I'll go ahead and turn it back to Mari, and we can switch to the next slide to talk about the process to talk about where we are in the state.
So, as you heard at the beginning, our program is run out of the Second Judicial District Court. We started expanding in 2021 when we entered into an agreement with the Third Judicial District to provide FSP services in Doña Ana County. Between September 2023 and December 2023, we continued our expansion of the FSP, and we entered into agreements with 6 more districts to offer our services. These include the 5th Judicial District, which is comprised of Chavez, Eddy, and Lee counties, 6th, which is comprised of Luna, Grant, and Hidalgo counties, 7th Judicial, which includes Sierra, Catrins, Socorro, and Torrance counties. The 8th is in Taos, Colfax, and Union counties. 9th Judicial is comprised of Curry, Roosevelt, and the 12th is Lincoln and Otero. I've had to learn about the lay of New Mexico, and I've learned all the counties through this process. We have expanded our program and now offer FSP in 8 of the 13 districts in our state. On this map, you can see the entire area of the FSP outlined in green. So we have a big chunk. There are foreclosure mediation programs operating in the 1st District and 11th and 13th. However, we are not affiliated with them, and so homeowners in foreclosure would need to contact them directly. If a homeowner does contact us that come out of any of those counties, we are happy to help them find contact information and get them connected. If you want to go ahead and change slides, Lisa, Amy is going to continue with what cases, how they're referred, and who can participate.
Great. So for the process of referral and the types of cases that are referred to FSP, cases are referred to FSP when the foreclosure complaint pertains to a residential mortgage loan that, when made, was for an owner-occupied residence of 4 units or fewer. What you'll note in that is we're not dealing with commercial loans within our program. So all newly filed foreclosure cases are referred to FSP. Now, cases may be removed from FSP at some point in the process for a variety of reasons, but if the litigants want to return to the program, they can file a motion for re-referral to our program. Judges may also look at older foreclosure cases and believe that they may benefit from our program, in which case a judge may refer an older foreclosure case to the program as well. Now, there are some individuals who can participate in the program, including homeowners and their heirs and beneficiaries. We do often have cases in which individuals may have inherited a property that is still subject to a mortgage. So certainly there are some special rules and regulations and perhaps requirements as well that will need to be met by those heirs and beneficiaries, but we do speak with them a lot in this program. So I'm going to go ahead and turn it back to Mari so she can talk a little bit more about the process.
If you'll change slides, Lisa, please. All right, so how does the FSP process work? Well, it starts when a borrower does not make their mortgage payment or multiple payments. There's a period of time, usually around 3 months, where they have an opportunity to work something out with the mortgage company before legal action is taken. During this time, they'll receive a default letter that is required to be sent by the mortgage company with specific information, and it includes how to and how much is needed to resolve the default and bring the loan current. If the default isn't worked out, a complaint is filed, and that is where the FSP comes in. We run monthly lists of all residential mortgage foreclosures filed in each of our districts. with the exception of Second. Here in Bernalillo County, our reports are run weekly because of the number of cases that come through in this district. And then we take those list of cases, and the FSP files what's called a notice of referral in each case. In Doña Ana County, there's the only exception is they have an order of referral instead of a notice. And so then this notice or the order is mailed to the property address. Sometimes homeowners will receive the notice of referral prior to getting served the complaint, and then sometimes they get served the complaint before they get the notice. It just depends on the timing. Once that notice of referral is filed, the case, as Amy said before, the case is put on a stay, meaning the mortgage company cannot evict or remove a homeowner or an heir or occupant from the property, and the parties do not have to file any answers or pleadings. The legal case is stopped to allow the FSP process to move forward. If you'll change to the next slide, please. All right, I know this is pretty tiny. The notice and attachments, there are 10 pages for notices and attachments that are filed and mailed. These are the first 4 pages that you'll see, which is the actual notice, and it contains specific requirements for the parties and for their participation in the FSP. A critical requirement for every case referred to the FSP is that the homeowner or heir must watch an orientation video and complete a homeowner information form. If this doesn't happen, the case will be released from the FSP. We provide about 6 weeks for a homeowner to complete this requirement, and within the notice, it's clearly visible what your deadline is. This video that you'll watch provides general information about the FSP process and expectations for homeowners or their heirs. The form gathers contact information and general information about the loan and a homeowner or heir's intentions and whether there's a need for an interpreter. The form is filled out and submitted online, so once we receive the completed form, we get an email. A settlement facilitator is assigned, and a telephonic initial status conference is scheduled about 30 days after that point. Would you please move to the next slide? This is the last page of the notice and the attachments, and it clearly delineates the deadline. It usually comes out on a yellow piece of paper, so it's very striking. It catches your attention, and it contains instructions about watching the orientation video and completing the form. There is a QR code and a URL for accessing the video and the form. The FSP is very concerned that defendant homeowners or their heirs are able to participate in our program. So we also have a phone number there that you can call if you need help. The video can be watched and the form completed using a smartphone, a tablet, a personal computer, and you have the ability to access the video and form 24 hours a day, 7 days a week. Here at the courthouse in Bernalillo County, we have public access computers that are available if you don't have the technology to watch the video and complete the form, and we can help you access that here. In other districts, we've had homeowners assisted by clerk's offices in their local courthouse to watch the video and complete the forms. You just need to ask. Sometimes there's computers available at libraries and community centers, but if you call us, the FSP will try to help homeowners figure out where they can get this access. We routinely have homeowners and heirs call the FSP, and our judicial specialists will walk homeowners through accessing the video and completing the form. We've even had a couple of occasions where we assisted incarcerated homeowners by running the video so they could listen, then assisting them to type in their answers and questions to the homeowner information form so they can participate. We do what we can to ensure homeowners and their heirs who want to participate have the ability to complete these requirements. As I said before, and I believe Amy mentioned it, there's a deadline to complete these requirements, and if that deadline is missed, the case is removed from the FSP. If a homeowner misses that deadline, they always have an opportunity to file a motion and request referral back to our program. And I don't believe I've ever seen a case where that was denied. So now I'm going to turn this back to Amy to go through the process from the perspective of a homeowner who has completed these requirements. Thank you, Lisa.
All right, thank you, Mari. And there are really a number of options that may be available to homeowners in our program. The two main categories of options are retention options, which I'll be discussing, and then Mari will be covering non-retention options a little bit later. So if Lisa, I could have you actually switch to the next slide just very briefly, and then we'll toggle back. This is, and I know it is very small for the viewers here, this is the homeowner information form that Mari was mentioning earlier. So the case is referred, the stay begins, the homeowner or the beneficiary or heir is watching that orientation video, and then they're filling out this homeowner information form. So why is this significant? Well, this is the first piece of information that the settlement facilitator will receive that indicates what the participant in the program would like to do, whether they would like to keep the property, whether they want to sell or pursue other non-retention options. So you'll see here, hopefully on your screen, we get basic information. So we get contact information such as a name, address, telephone number, email. We also make sure that we send email summaries after every single status conference that we have with participants in the program, including from the very first initial status conference all the way to the end when hopefully we have a resolution of the matter. If we have an elderly homeowner or someone who does not have regular access to email, we will mail those summaries out. And those summaries do include information about when our next call is scheduled. Looking through this form a little bit more, we can also see where they are in that process. So have they taken steps when they are working with the plaintiff to see if they can keep the property? Have they started filling out any applications? There's also an indicator on this form of whether an interpreter is needed. Whenever we have a non-English speaking participant, the case is flagged as needing an interpreter, and we make sure that we have interpreters on the line for every single call. The other important piece of information on this form is that there's a section for the participants to let us know a little bit more about what happened, perhaps what caused the default. People often give us a history of their interactions with the servicer. That's a lot of very important information. Sometimes people give us information if they have a disability or if there's something that could prevent them from fully interacting with and being a part of this program if we didn't know. So it's a really critical piece of information, and that gets us started on whether this person wants to, in fact, retain the property. And let's, Lisa, if you could toggle back to the slide before this, that would be great. Thank you so much. So I send typically a welcome email after I look at the homeowner information form. And then we will receive what's called the lender information form. Now that information is from the plaintiff, and they give us information about two important numbers that are significant for retention options. And those are the reinstatement and payoff amounts for the loan. The reinstatement amount is just basically the amount that would be needed to be paid to bring the account current. So it would bring you up to speed if you are a participant in the program, a homeowner, and then you keep the terms of your loan and you make payments and you move forward. We also get what's called the payoff amount. The payoff amount is the amount that would be required to pay off the loan completely. Reinstatement and payoff are always retention options that are available to people in our program in your typical case. However, people don't always have that kind of money sitting around. It depends on how long the matter has been in default, what their personal finances look like. However, that's okay. There are usually other retention options that may be available depending on the type of loan and the financial circumstances of the individuals involved. So the next step, if reinstatement and payoff are not options in a particular case, the homeowner or the borrower will fill out what's called a loss mitigation application to be evaluated for retention options. Now, those loss mitigation applications are subject to federal rules and regulations, as I believe Mari mentioned earlier. Depends on the type of loan. Also, for privately held loans, there may be investor guidelines. But what you need to keep in mind for this is that it's just a very structured review and process. Now, when those applications are submitted, the plaintiff will come back within a specified time to either say, this application is facially complete, we don't need more documentation from the borrower or homeowner, or actually we do need some additional information, in which case they will submit a missing documents letter. So during our calls, we will work through the homeowners or the borrowers, heirs, beneficiaries in this process. We will work with them to make sure that everything that's needed for these applications is perfectly clear. And then hopefully there will be a decision letter. Now, in a decision letter, there may be an offer. These can include a loan modification, which may alter the terms of the loan by extending the maturity date and changing the interest rate, usually to market rates. There may be an offer for a partial claim or payment deferral, which essentially takes the amount that is needed to reinstate and places it at the end of the loan in a second mortgage to be paid in full after the first mortgage is paid off. There may also be an offer for a repayment plan, which gets people up to date on their missed payments over a period of months. There may also be a trial payment plan where specified payments need to be made for a number of months on a trial basis before a loan modification is offered. It just depends on the type of loan and going through what's called the waterfall of potential retention options to see what could be offered to a particular homeowner or borrower in our program. Now, sometimes, unfortunately, an offer cannot be made. In that case, as settlement facilitators, we speak with the homeowners or borrowers or heirs or beneficiaries and see if there's a way perhaps to decrease the expenses that are in the household or increase income. For example, I've had people get roommates or sometimes adult children have moved back in with family members who are participating in this program. But we see if there can be a change in circumstances and then if another application should be submitted. However, sometimes that's not the case and non-retention options may need to be considered. Or a homeowner or borrower, heir or beneficiary may want to pursue non-retention options from the very beginning. So let me turn it over to Mari so she can discuss those a little bit more.
Okay, thank you, Amy. Lisa, can you move forward 2 slides? Perfect. So, much like Amy's description about a case where the homeowner wants to keep their home, there's the same process when a homeowner wants to give up their home. It follows the same route. However, non-retention options may need to be considered when a homeowner is denied for all retention options, as Amy described. The FSP ensures participating homeowners and heirs have the opportunity to explore all of their options, both retention and non-retention. While we hope that a homeowner who wants to keep their home can keep it, sometimes they're unable to because their application is denied for financial or other reasons. At this point, the homeowner can try to work out an option to allow them a graceful exit. Some of the possible options include the homeowner could try to sell their home for full market value to capture any equity in the property. It's possible they can apply for a short sale in cases where the home would be sold for less than the mortgage loan because the market value is less than the loan and they're underwater essentially. But it does require an application with the mortgage company reviewing, and they may or may not approve a short sale. Another option is deed in lieu of foreclosure, which is where a homeowner deeds the property back to the mortgage company. This also requires an application and approval from the mortgage company. And sometimes that is not even an option available depending on the type of mortgage it is or if there's an investor. A homeowner can choose to stipulate to judgment, which means to agree to a foreclosure judgment and ask for concessions. Sometimes there's relocation assistance available in certain situations to help a homeowner relocate. There's a possibility of asking for an extended move-out date to give a homeowner time to pack and move. The homeowner just needs to ask the mortgage company if any of these options are available. And finally, in situations where an heir who doesn't want to be involved in the process, or they don't want to try and save the family home for whatever reason, or they don't believe they have any interest, they have the option of disclaiming their interest in the property. I just want to reiterate that the settlement facilitator cannot force the parties to settle or make the mortgage company agree to any of these options. Everything needs to be applied for, and they need to make the determination. Lisa, if you would move to the next slide, please. Thank you. So as a reminder, the FSP settlement facilitators do not represent homeowners or mortgage companies and cannot give any legal advice. However, there are a number of resources, and this is the slide that we're showing you. These resources provide housing counseling and can offer legal advice and sometimes representation. Housing counseling is generally free to anyone, but there are often income restrictions for free legal services, but you should always ask about these services. There may be even options for legal services on a sliding scale. Some of the government-insured loans, like FHA and VA, have loan technicians who can provide information and assistance when you call in. This list of resources is provided to every homeowner who participates in the FSP. It's also, the information is on our website. Some resources can also provide service across some of these resources do provide services across the state, but some are limited to certain areas of the state. You just need to ask them. And in addition, some of the legal service providers can give you information about other areas of law that may impact your decision during this process. At this point, this brings us to the end of our presentation, and we want to thank you for joining us today. If there's any questions, I'll turn this back to you, Juan.
Thank you, Mari. I have a couple of questions for you.
Okay.
And I know there's a lot of factors involved, but on average, how long does the settlement process take?
So, of course, the answer is it depends. It can be as short as 3 months, depending on how much the homeowner has been involved from the beginning. They may have already submitted an application to the mortgage company before they came into the program. And then sometimes it takes longer. We go through the process of them applying for loan modification and other retention options. They may get denied, and then we give them an opportunity to stay in the program and try to work through a non-retention option. And for example, if they wanted to sell their home, we give them time to get a realtor, to get advice, to figure out how much it's worth, to get it ready to put it on the market, and then a marketing period. So it's kind of hard to tell you exactly how long it could take. 3 months, it could take a year. It just depends on the facts and circumstances in each individual case. But we do want to give every homeowner the opportunity to explore all their options, to make an informed decision and to be part of the conversation on how this process will go and what the outcome will be.
Okay, another question for you here is statewide, how many new cases are referred on average each month and each year?
Right. I did not look up those calculations. I want to say that in the districts not in Second Judicial, the average cases referred on a monthly basis range anywhere from 2 cases to 30 cases. But that's not every single month. It varies. In Second Judicial, we refer anywhere between 6 cases and 25 cases on a weekly basis.
Another question. If an owner mortgager has died and an heir wants to try to retain the home, does the foreclosure settlement program require that probate be opened before FSP can proceed?
So that kind of steps into the legal arena, but we have cases where heirs come into the program even before they filed a probate, and they are able to have a conversation with the mortgage company's attorney and the mortgage company representative about what is going to be needed for them to be considered a successor in interest to be able to proceed through the process. So it depends, but we don't stop any heirs from participating if they haven't filed a probate. Maybe that's the easier answer.
All right. Once an agreement has been reached between parties, are there options to revise the agreement if necessary?
That also depends on what type of agreement. As we indicated, the industry and loss mitigation review is very structured because of federal laws and regulations. If it would depend on the agreement. You usually cannot get an offer modified unless they re-review you. If it's a different type of agreement with respect to a non-retention option, there may be possibility of revising the agreement, but I haven't seen that happen. It would depend on the situation.
Another question on the FSP. Other than being a residential mortgage, are there any other eligibility criteria such as income?
No, there's not an income requirement.
And no other criteria, eligibility criteria? It's anyone facing a mortgage foreclosure?
You should be an owner. You should be a borrower, homeowner, or an heir, generally. There have been some circumstances where a tenant has participated, but the homeowner also participated because they were trying to work something out between them and the mortgage company.
Great. I don't see any other questions right now. However, if any of you in the audience do have a question, you can either raise your hand or post it in the Q&A box. Again, I don't see any additional questions. So Amye, Marisol, thank you so much for your presentation today. I do want to remind those of you that are online here that we will be sending out a link to this recording. It gets posted in about a week. And when we send out that link, we will also attach the presentation that was used today. So you will have a copy of that presentation as well. I do want to go back here to share screen for a second. And I do want to point out we have some legal fairs, etc., coming up. I'm going to put that on the screen now. And here we go. Again, we have a legal fair tomorrow in Las Vegas, New Mexico from 9 to 3 p.m. It's going to be on campus. There's a legal fair on Taos this Friday that will be at the district court jury assembly room. There will be statewide teleclinic online available on Thursday, October 23rd. And for those of you that are seniors, The Legal Resources for the Elderly program will have multiple events, as you can see there, in 2025 and 2026, with the next one being November 10th. I'd like to thank everyone for putting this event together. Lisa and Alma with our Administrative Office of the Courts and help do all the registration and tech work for this. And Marisol and Amy with the Foreclosure Settlement Program in the Second Judicial District Court. Thank you so much for your presentation. I'm going to stop the share, and I'm going to also check questions to see if any additional questions were posted. Let me take a quick look. Yes, there is another question that has been posted. So in repaying the lender, how long does the borrower have to show good faith till returning to original payment?
Like a repayment plan? Is that
Yeah, and again, I think, as I would understand it from what your discussion earlier today, that restructured financial payment is the new one going forward, and I don't think you returned to the original. Is that correct?
So if it's a repayment plan, the lender dictates the terms of that once they do the review. If there's a loan modification, there are new terms in the loan modification that would dictate interest rate and the payment amount and the term of the loan. So I'm hoping that answers that question.
Great. Any other questions from folks? Great. Well, again, thank you all for joining us today. Again, this will be posted to the New Mexico Courts YouTube channel.